So Rahul Gandhi, a leader of Indian National Congress, has been disqualified from his position as a member of parliament after being convicted in a defamation case. In this video, we would understand the difference between suspension of sentence and suspension of conviction and how it affects in reinstatement of his membership to the parliament. Congress leader Rahul Gandhi has been in the headlines due to his disqualification in that defamation matter. But did you know that there is a difference in suspension of conviction and suspension of sentence, and the difference could lead to the reinstatement of his membership to the parliament? How? Let's explore. According to the Indian Constitution and Representation of People's Act, Rahul was disqualified from his membership of parliament after being convicted in the defamation matter, after which Rahul Gandhi appealed to the Sessions Court of Surat, which again got rejected. So while his sentence has already been suspended, his suspension of conviction is still pending, and if allowed, that could result in reinstating his membership to the parliament. So what exactly is the difference between suspension of conviction and suspension of sentence? So when a person is found guilty of a crime by the court, they are convicted, and the judgment on conviction is followed by an order of sentence. So Section 389 of CRPC allows an appellate court to suspend anybody's sentence pending the appeal and release them on bail if they are already in confinement. So although the CRPC does not explicitly mentions any provision about suspension of conviction, it does not prohibit it either. As a result, the courts have decided at times when an appellate court may suspend the conviction.
So, suspension of sentence refers to a situation where a court has found an accused guilty of a crime and has imposed a sentence, but when the convicted person files an appeal, the execution of the sentence is temporarily postponed, and the accused may be released on bail. On the other hand, the suspension of conviction refers to a situation where the court not only suspends the sentence but also puts a temporary suspension of the conviction order. The Supreme Court of India has observed that an order granting a stay of conviction is not the rule but an exception to be resorted to in rare cases depending upon the facts of a case. Did you know that in case of Navjot Singh Sidhu versus State of Punjab and others, the apex court had granted suspension of conviction to Sidhu, who was then the sitting MP when he was convicted under Section 304 of Indian Penal Code and was sentenced to a 3 years rigorous imprisonment and a fine of rupees 1 lakh. To conclude, the suspension of conviction is a rare occurrence, and courts have made it clear that an order of stay does not render the conviction.
So if you liked my video, do not forget to hit the bell button and subscribe to my channel. Leave your feedback in the comment section below, and let's meet again next week.